What happens if you've bought a gift voucher, paid a deposit for goods or services, or signed up to a Christmas savings scheme, and then the company you've paid goes bust? In our consultation paper, we explain that the existing law doesn't offer consumers much protection on retailer insolvency, and we ask whether consumers should have better protection. We looked at what happened to consumers when retailers like HMV, Woolworths and MFI collapsed. In fact, the losses to customers were often relatively low. Many gift vouchers are for small values and are usually given as presents. However, even if no real hardship is suffered, expectations will be disappointed. One problem is that consumers often don't know about the legal position and often don't realise that their prepayments could be at risk if the company goes bust. There can be also confusion in the media about what consumers' rights are. If consumers have paid by credit or debit card, then they may be entitled to a refund from their bank, but many people don't know this. We think that more should be done to ensure consumers are aware of their rights to a refund. But payments by cash and cheque are not protected, and this often means that the less well-off suffer the most. Significant losses can be suffered, for example, where someone has paid a large cash deposit for an item like a washing machine or towards a bathroom suite. So what steps could retailers take to protect consumer prepayments? Well, they could pay consumer money into a trust account or buy insurance to protect consumer payments. But these options can be impractical or too expensive. We look at making these options more accessible. The costs of requiring protection for all prepayments may be excessive, so we ask whether promoting voluntary schemes for retailers might be enough. But in the case of Christmas hamper clubs and other schemes that are promoted as being suitable for saving, we think that protection of consumer savings should be mandatory. For consumers who have paid large deposits, we suggest that cash payments of more than £100 made in the weeks leading up to the insolvency should be moved up the queue of creditors in the event of an insolvency. We also propose new, simpler rules on the transfer of ownership in goods to make it easier for consumers to claim goods that they have ordered and which the retailer has put aside for them. Finally, we consider the possibility of allowing businesses to register a consumer charge in the same way as a company mortgage or floating charge. This would give a voluntary priority to prepaying consumers, making them more likely to receive a payment from the insolvent company. We ask for views on all of these possibilities. The consultation paper and a summary are both available on the Law Commission website. We hope to hear from as many interested parties as possible, including consumer groups, retailers, insolvency practitioners, and finance providers such as banks. The closing date is 17th September.